Production? Oh, absolutely. Okay.
There are waters on stage on the way here.
Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. Very good. And what more urgent, what more important time to have these great nonpartisan discussions than as we enter a presidential election. We see before us every night the great polarization that surrounds our political discourse, and here at the Constitution Center we are an enclave of civility that illuminates the constitutional debates at the center of our national life. We are doing that with just a blockbuster series of panels and symposia related to the presidential election this week on Lincoln's birthday, February 12th, we open our new Headed for the White House exhibit. And it's a thrilling exhibit of the constitutional dimensions and the history of presidential campaigns. We have a blockbuster opening night panel on Thursday, February 11th, with two of the greatest presidential historians in America, Annette Gordon-Reed and Jeffrey Ward, who wrote that great script for the Roosevelts documentary. He will be here. Please come. I think it's sold out, but just write to me and we'll figure out a way to get you in, because I'm serious. We'll do it, because you've got to see it. It's just going to be amazing, and there'll be a party with, and you can see the exhibit and come on February 11th. And then just see what's coming up. Next week, February 16th, has the president gone too far on immigration? An amazing debate with the people on both sides of that important topic. Voting in America with two great voting rights scholars on February 18th. Presidential primaries on the 25th. A Reagan biography. Boy, it's just going to be all presidential debate and the Constitution all the time for this season and for the spring. It's hard to imagine a better panel to kick off this presidential focus than the one you're about to hear. This is these are among the most distinguished scholars and commentators on executive power in America, and this panel has a very special bit of poetic justice because one of our, well, first of all, it's moderated by Daniel Green from the Templeton Foundation. You know, the Templeton Foundation has supported our phenomenal Coalition of Freedom Advisory Board, co-chaired by the heads of the Federalist Society and the American Constitution Society, the leading conservative and liberal lawyers organizations in America. And that coalition is supervising all of our interactive Constitution Online, our traveling debates which are going around the country, and so many of these panels which are bringing both sides together for civil discourse. So we're so grateful to them and to Daniel. And then one of our panelists is the gentleman who set this great Coalition of Freedom up and running, Dean Reuter from the Federalist Society. It was almost 3 years ago when I first started here that I went to Dean, who's vice president and director of the practice groups of the Federalist Society, and said it would be wonderful to bring FedSoc and ACS together, and he helped make that possible, and I'm so glad to welcome him back. And then we have contributors to this really interesting new book called Liberties, Nemesis, who are going to join Dean. Dean is one of the editors. We have his co-editor, John Yu, my old friend and classmate, and he is the Emanuel Heller Professor of Law at the University of California at Berkeley and visiting scholar at AEI. And then we have two of the authors of the book, Linda Chavez, chairman of the Center for Equal Opportunity, and Ambassador C. Boyden Gray, founding partner of Boyden Gray, adjunct professor at George Mason, and a great constitutional scholar. Ladies and gentlemen, please join me in welcoming the authors and editors of Liberties, Nemesis. Please. Have fun. Enjoy. Have fun. Enjoy.
So, welcome everyone. This is
a book that, of course, involves a lot of constitutional issues, but it also involves administrative law. This is the law that governs agencies and citizens' rights vis-a-vis the agencies. When I took administrative law in law school, I thought, this may be important, but it's going to be a little dry. But it really opened up my eyes to how much of our interaction with the government and our personal relation with the Constitution as a citizen really is mediated by these agencies, which even a lot of lawyers sort of ignore or don't fully understand. And of course, that's how most of the expansion of the state has occurred. So, John, Dean, how did you sort of get on this path, realize the scope and scale of the problem, and decide to put this book together?
That's a great question and a great observation in your question. Let me start by thanking Jeff Rosen and the Center for having us here today. We're all thrilled to be here, and we so much appreciate the forum. I think, in answer to your question, it's understood by most people that we're in the era of big government, and government, if it does anything really well, it's expanding. That's one thing it does very well. What people hadn't focused on, I don't think, is that the greatest area of expansion seems to be the administrative state, what I refer to as the administrative state, the agencies of government. And one of the reasons we wrote the book is, one of the reasons I helped put the book together was, I feel that's unfortunate at best to have the growth in the administrative state, because that's a cadre of people who are unaccountable to the citizens, to the voters. And that's antithetical to the constitutional design. The structure of the Constitution is designed in a way that the levers of power are supposed to be in the grips of people who are accountable to voters. And the administrative state is not that way. So I felt it was an important thing to discuss and to expose and then talk about. So we recruited 35 experts, 2 of whom are with us today. These are people who have been at the highest levels of government in all branches of government, including within the agencies, to examine exactly what's happening at many of these different agencies, but then also to take a broader thematic look at how we got to where we are today and what might be done about it.
Anything to add, John?
Oh, well, first let me also thank Jeff for inviting us to join you today. I've known Jeff since college, and we went to law school together. And I still remember the paper Jeff wrote as a law student, which is funny given that he's the head of the Constitution Center, because his paper, if I remember, was, could the Constitution have an unconstitutional amendment in it? So but he's from the beginning, he was wondering, should we get some parts out and put some new parts into the Constitution? And it's really great to be here at the National Constitution Center. I've been here many times. I was here at the opening, if you remember, when the city of Philadelphia almost killed Justice O'Connor with the falling flag, just missing. And I remember she go, oh gosh, that was close. And then it's really great for me to come back home to Philadelphia. Although it has changed a lot since I graduated. I went to Episcopal Academy. I graduated in 1985. And I was taking my co-editor around the city this morning. And the city is so nice now. I could not find any place that served scrapple for breakfast. What is going on? I was very I had talked up scrapple, right, everything in the pig but the oink. And I couldn't actually produce a slice for my friend Dean. And I really want to thank Linda and Boyden for contributing to the volume and for being here. They're both people that I looked up to, admired in the 80s when I left high school, started to go to college, and started to read about participating in public affairs, and they were both in their time outstanding spokesmen. I feel very lucky that they're in the book. And that's sort of why, just a roundabout way of answering your question about why we put together the book and why we hoped it would have an interesting appeal to people from both sides of the aisle, is that whether you're Democrat or Republican, I heard the whole nonpartisan shtick in the beginning, conservative, liberal, Republican, Democrat. I think one thing that has gone forward during the last really 70, 80 years has been the constant growth of the administrative state. And you could look at all kinds of things that afflict both parties as products of that, to the point where I think people don't even know what the administrative state is doing. The right hand doesn't understand what the left hand is doing. You could think of Hillary Clinton's email problems as a function of how confusing and overburdened by bureaucracy we've all become, that the Secretary of State doesn't even know which systems to use and which emails are coming in or going out, or of course, the Obamacare problems with the healthcare.gov website. Same thing, there are plenty of things under the Bush administration that are similar. And so that maybe rather than focus on all these problems, just take a step back and see, is there something about just allowing the growth of government to get bigger without really thinking about what it should look like that is causing all of these eruptions that we see on a daily level that cause us a lot of problems?
And if you haven't looked at the book yet, it really does cover a huge range of issues, some of which we've had discussions about other fora at the Constitution Center, like religious freedom and freedom of speech. But marriage, Fannie, Freddie, it's financial, it's things in our everyday life that affect us all as individuals. And in Linda's chapter on immigration, you make an interesting point. You say that the Immigration Reform and Control Act of 1986 created what you call a bureaucratic nightmare, and that it made all employers into quasi-enforcement agents. And you go on to explain just what type of employers, like even if you're employing someone to come and do household work, you can be implicated. So can you just elaborate about how it's made us these quasi-enforcement agents?
Well, thank you very much, and it is a pleasure. It's great to be with Jeff and to be with my fellow authors and editors on the stage, and most importantly, it's a great privilege to be here in the Constitution Center. It's very interesting. The whole issue of immigration has been a contentious one for as long as I've been in public policy, and I've been in public policy for a very long time, probably a little bit over 40 years. And it has been an issue that has deeply divided Americans. And I have, frankly, I'm a conservative, I'm a active Republican, and I have had the same position on immigration for the last 30 plus years, as long as it's been in the public arena. And at one time, my position was pretty much the conservative position. We don't want government telling us who we can hire. We want to make sure that we have free market standards and that labor is able to flow as well as goods and other things through trade. It was a position, I think, that President Reagan held. And then in 1986, we passed the Immigration Reform and Control Act. And all of you have heard about the Reagan amnesty, and it is absolutely true. President Reagan gave amnesty to somewhere between 3 and 4 million people who at the time were in the country illegally. And a lot of people, I think, thought, well, how are we going to stop this from happening again? And so members of Congress came up with something called IRCA, the Immigration Reform and Control Act, and they decided that the only way to stop illegal immigrants from coming was to punish employers who hired illegal immigrants. But rather than focus on large-scale employers, they decided that they were going to put in a provision that makes any person who hires, even on a part-time basis, somebody to do, as you suggested, household work or garden work or taking care of kids, they were going to put an administrative burden on that person. That person was going to have to check whether or not the person they were trying to hire was legally present in the United States. There were a whole list of documents that could prove the legal right to work. The person would have to fill those out. And if you changed your mind as an employer and you offered the job to Mary, but Mary, quit after 2 weeks, you'd still have to keep that piece of paper in your files for at least 3 years. And same would happen the next person you hired. Well, what I've tried to explain to some of my fellow conservatives is that this is big government and Big Brother writ large. This is not the way to stop illegal immigration. And it didn't stop it. As we can see, we now have, depending on whose figures you believe, somewhere between 2.9 and 11.2 million illegal immigrants living in the United States. My contention is it didn't stop it because the legislature didn't do its job, didn't come up with a law that was flexible, that looked at the needs for labor in certain categories, that was skills-based, and that allowed more people to come in when we had a booming economy, as we did in the 1980s and 1990s, and fewer people to come in when we had economic problems. So that has been my emphasis. It's been something that I've worked on. Unfortunately, that legislative compromise never took place, and my chapter in Liberties Nemesis is all about why I think President Obama did something which I don't believe he was entitled to do. I don't like IRCA. I don't think it's a good law. I'd like to see it rewritten, but I don't believe that President Obama or any other president has the right to take a piece of legislation and ignore it or rewrite it. And he certainly doesn't have that right to do it the way President Obama did, which was to give his Department of Homeland Security secretary authority to write 12 memoranda that basically rewrote that law.
So as I said, huge range of issues. So from immigration to Dodd-Frank. Boyden, in your chapter, you talk especially about the Consumer Financial Protection Bureau, which certainly sounds like a good idea. This is the government finally protecting us as individuals, right? But you go on to describe some of the problems about the agency, and then some problems they've faced internally as well, with allegations of discrimination within the agency. Could you just explain to our audience some of the problems that you found there?
Well, there are many, many problems, but the principal one is that it is accountable to no one, this agency. It doesn't have to respond to the President of the United States. In fact, it can overrule the President of the United States if it feels like it. It doesn't have to respond to Congress because its money comes from the Federal Reserve Board, which prints it. It's like sort of giving Bitcoin to the CFPB. And the courts are limited as to what they can say about it because it gets special deference. And when it's dealing with a statute that has other bureaucratic implementers and enforcers, it has the single most important authority to interpret it and to enforce it. And I think the anecdote that best describes its sort of orbit outside of, it's like Pluto and some, outside of the American system is its renovation. It was originally planned, they took some property over from one of the other agencies, office buildings, and the renovation was originally planned and calculated at $50 million, and it ended up being something like $250 million. And it was just a runaway, outrageous, luxurious, palatial, and so there was a congressional hearing about this, and the chief of the committee asked Cordray, the director, well, who supervised this? And and Cordray says, I don't know. And the head of the chairman of the committee says, you don't know? And I'll quote you Cordray's answer. Who signed off, asked the Congresswoman. Who gave the authorization? And he shot back, why does that matter to you? And I told this story I was on a plane yesterday coming back from Boston with Tim Wirth, Senator Wirth, Democrat from Denver, sat on the Energy Committee for years. And he said he testified to that in utter shock. And I said, yeah, those are his words. And he said, oh. So no one can control this agency. And we wanted to try to challenge it. And it took 18 months to find a plaintiff. People don't like it, but no bank would show its face because their examiner could destroy them in minutes. And that's one of the problems with the administrative state. No one dares challenge anymore. And one day, parenthetically, I was driving with Doug Ginsburg, who has now gone into senior status, but at the time, he was the chief judge of the D.C. Circuit Court in Washington, which is the court that oversees regulatory issues like this, like immigration. And he asked me, this is about 4 or 5 years ago, why in the middle of the greatest regulatory boom, explosion in our nation's history, is the caseload of the court that's supposed to be watching over this declining? And I said, well, the reason is because the agencies have so much power now, they can intimidate anybody out of challenging what's happened to them in the Court of Appeals. Today, even with the addition of 3 extra judges to a court that already had the lowest caseload of any Court of Appeals in the country, now the caseload is so low that the judges on the court are begging other circuit courts around the country for cases because they're getting incredibly bored, because they're being intimidated out of being able to oversee this process. And so to me, it's very, very scary when you can't. We finally found a plaintiff to challenge this rather unconstitutional monster which has to answer to no one. And he is the chair of the National Bank of Big Springs, Texas. How many people here are from Texas? Have you ever heard of Big Springs? Well, you've been there, but you may know him. He's a fine man. He's an excellent man, Jim Purcell. He's a wonderful guy. But it's a small bank, 40 people, 2 branches, $270 million asset base. And he was fearless, and he was absolutely fearless. But less than 12 hours after the case was filed near midnight electronically, he was called by his bank examiner at the Treasury saying, "What are you doing? Why didn't you tell us? People upstairs want to know. Who are you talking to? What press are you communicating with?" So this is all kind of, to me, kind of scary. And so to conclude all this, you sort of ask, well, how could all this happen? How could you have agencies with no accountability whatsoever? And this is across the board. This isn't just the CFPB. The CFPB is a more sort of egregious example of it, but most of the agencies have this kind of authority to push people around and intimidate and blackmail and whatnot. How did this happen? Well, there always has to be a sort of a profit motive behind it, and I'm afraid to say that big business in America doesn't altogether dislike it. And they get these regulations. They don't like them, but the regulations they can afford to comply with. But guess what? It's a monster for their smaller competition. And so I perhaps shouldn't be so uncharitable to Jamie Dimon, the chairman of J.P. Morgan, but he said publicly that Dodd-Frank, which he publicly criticizes, but he will privately say, although in a public context, Dodd-Frank is my moat. And he didn't mean moat in his eye, he meant M-O-A-T. This is my protection against competition. And Lloyd Blankfein, the head of Goldman Sachs, has said barriers to entry to our industry have never been higher, quite happily. So big business cooperates in a way that is not necessarily totally voluntary, but when it happens to them, they don't really complain very loudly. And so we have sort of a system of big business and big government. And one final sort of anecdote, a woman who I was served in Europe as ambassador to the EU, and I got to know the head of competition there, a woman named Nellie Cruz. She comes over, I introduce her to speak, and she asked me, because Europe is this is 5-6 years ago, grappling with Greece. How did Greece get in the European Union when they're in the shape they're in? Why did we admit Greece? And it turns out that they had the wisdom to hire J.P. Morgan, which cooked the books, to mislead the EU as to what was going on in Greece. And she said, "What do you think about Goldman Sachs?" I got to be very careful there. I hope the employees of Goldman Sachs. And I said, "Well, Nellie, there really isn't time to go into it, but let me just tell you that it's known affectionately in Washington as Government Sachs." And she said, I get it. That's all you need to tell me. So that's my story, and I'm sticking to it.
Yeah. There's an old saying that no one wants to be in a regulated industry until they are, right? And then you can keep everyone else out. So as has come up a couple of times already, it's important to emphasize that this isn't a one-party thing. This is over the course of many presidents, and we could go back very far, decades back. But one case that, of course, is hugely important in constitutional and administrative law and comes up over and over and over again in this book is Chevron versus Natural Resources Defense Council. This is a 1984 case, so it really has to do with the Reagan administration. Could one of our panelists kind of just take a stab at explaining for the audience what the context of the case was and what it has come to mean for administrative law
John,
going
you
forward?
should do this, but I want to add some words after he's.
Okay.
I mean, he's the academic expert. He's the real.
I'm going to defer to him.
Yeah.
But I wish I was paid by Chevron rather than by California, the state which is going quickly. Well, we're not going as bankrupt as fast as big oil, but we're giving them a run for their money these days. So Chevron is this interesting little case, but it has huge constitutional impact. And I think it's really what unleashed the agencies to grow as quickly as they have. So it's really a case about regulating a Chevron facility. But the question really was, if there's a statute that's unclear, and most of the statutes that Congress passes are quite unclear. To give you an example, the Clean Air Act, which is one of the most important regulatory statutes in our country, really boils down to the EPA and the federal government shall regulate the air so it is clean. And then that's all it really says. And then the agencies have to figure out what to do based on that. And so Chevron raised a case where one of these statutes was challenged, and the agency gave its interpretation of the law, and Chevron challenged it, had its own. And what happened was the courts, and this is a Supreme Court case, eventually said, when a law is ambiguous, we, the courts, will not judge it for ourselves. We're going to defer to what the agency thinks the law means. It's quite extraordinary because Chief Justice John Marshall in Marbury versus Madison back in the beginning of our country said, it's the judiciary's province to decide what the law means. But confronted, I think, with what Boyden's talking about, the massive size of administrative state, the amount of things it does all the time, the courts essentially said, we're going to withdraw. We're not going to carefully review what agencies do anymore. And I think when that happened, and it goes to what Boyden and Linda were saying, this is not a Republican-Democrat thing. This was actually Republican judges on this DC circuit and then the Supreme Court. And it was very much pushed by Reagan, Bush judges, because if you remember back in the 80s, they wanted to deregulate. And so they didn't want the courts to second guess their deregulatory agenda. I think now, looking back on it 30 years later, what those judges didn't realize was what happened if the administrative state wanted to re-regulate or even go farther. That meant they would still have to let the agencies go forward. And so the Chevron doctrine, though, one way to think of it is that's each branch of government under both political parties has contributed to this growth of this huge administrative state. So Congress, as I mentioned before, what they've done is they delegate huge amounts of power to the agencies. Presidents then, and this goes to the immigration point, are confronted by a gigantic state doing all kinds of different things. So what they try to do is they try to expand their power to try to control it, to rationalize it. Even though I think it's so big, no one person or one office can really do that. And then the courts have gone in the position where they're just going to defer. And that really is very different, I think, than what the framers here in Philadelphia in 1787 over at Independence Hall, what they designed. They never really thought the administrative state, there would be a big executive branch, a big administrative state. I think they thought the president was really there to protect the country's security, but that domestic affairs, most of the big decisions should be up to Congress, not the agency. And then they thought the judiciary would be around to be an independent check on what the other two branches were doing. If you think about it now, we have a system where the Congress gives all the power to the agencies, the president tries to control those agencies, and then the judiciary basically doesn't interfere. And that I think, ties into this kind of both presidential overreach, but also the story of the judiciary just gave up at some point in the mid-'80s from trying to control it.
Yes, and I think the courts have now realized that they kind of let the ball drop, and they're reconsidering all of this and beginning to wise up to what they've done by kind of letting this delegation deference to these big agencies go. And now they're beginning to turn things around and reverse them. And it's interesting that in the most recent case, the case about Burwell, that healthcare case, state exchanges, were they subsidized, were they not? The court ruled that this is a really big issue, a really important issue, and an issue like this couldn't be delegated to the agency. That's for us to decide. So that was a big issue exemption to this rule. Some 10 years ago, in a case involving EPA and its unlimited power to regulate pollutants, on the surface unlimited power, the Democratic Solicitor General, without EPA's permission, against EPA's wishes, put in a stopping point, put in a limit on what EPA asserted it had authority to do. And the interesting thing is that Justice Scalia, in the opinion, says that when you have a claim that Congress has delegated too much unrestricted power to an agency, the review of that is not under Chevron, not under this deference doctrine. The court pays no attention to what the agency says. The court has to decide itself. So we have two huge loopholes or exceptions to this doctrine. So I think it's being in the process of being unraveled or reordered by the courts. Does that make any sense? I hope people understood.
I'd just like to observe that one of the big changes that I've seen over my time in Washington is the growth in the size of both the administrative agencies, but also the size of the staffs of Congress. I mean, just walking through the hall here and seeing the framers of our Constitution was a handful of men gathered in a room. They drafted, they rewrote, they edited themselves. Now we have a legislature that is limited in size by our Constitution, but the staff is not limited in size, and in fact it has grown and grown and grown. And what happens is you end up having 800-page bills, and the members who are going to vote on those bills have not read what they say. And that kind of power that comes just from size is certainly true in the agencies as well. The size of government makes things, first of all, it removes them from the authority of those who were elected to make decisions. And in this battle, the judiciary, which doesn't have huge amounts of staff able to weed through all of this, is always going to lose the battle, just in terms of having the resources. And so you have this, self-perpetuating machine which grows bigger and bigger and more powerful, and it does grow under both Democrats and Republicans. When I worked on Capitol Hill in 1972, I was on the professional staff of the House Judiciary Committee. This was a committee that drafted the Civil Rights Act, that dealt with constitutional amendments, a very important committee. There were less than 50 staff members, and that included clerks and secretaries on that committee. I don't know what it is today, but it's probably several hundred today. And at the time when you had fewer staff, you had members who actually were involved in the process, owned that process, understood the words that were in the laws, and could defend them. Now it's a bunch of unelected young people who basically are writing the laws that all of us are affected by.
Let me just add to that. I'm talking too much, but when I first came to Washington, I did some appellate litigation involving constitutional and administrative law. I also did quite a bit of lobbying on antitrust law, and in those days, John, you weren't even at Episcopal High School. I don't know where you were. You were in grade school somewhere when all this started, but they used to have what's known as markup sessions. That is, they would actually go through line by line of these bills and amendment. If I talk to someone young coming just out of law school or off a clerkship or something, and you say, there's a markup session. There's a what session? I mean, people don't know that there ever were markup sessions where, for example, it was impermissible to introduce an amendment to the third degree. Now, I've quizzed young lawyers, do you have any idea what it is to introduce an amendment to the third degree? Oh, the third degree? The what? Is this some kind of torture? And I said, no, it's an amendment to the third degree. And now, there are no markup sessions. There are no, it all gets drafted by the leadership and by these staff people, and no one's ever read it. And it's like Pelosi said, we got to pass this law in order to understand what's in it. And that's, that's what that's what she said about health care. And this is a really tiresome thing. And I'll just drop one little hint, which really disturbs me, but I've talked to a lot of congressmen in the course of why has this happened over the course of the last 30 or 40 years as John, you was getting educated. Why has this happened? And most congressmen now don't have time to attend markup sessions because they go across the street to get on the phone to raise money. Mm-hmm. And that is a real factor in how much time they can devote.
Throw one.
Let me just throw one question out, and then we'll move to some audience questions. But, I don't think it's surprising that anyone, any body is going to try to take advantage of all the power that they have. But that's why, since elementary school, we're all taught there's the separation of powers, right? So that's an important aspect to consider here. The executive, of course, is the source, the nature of the powers we're talking about. But the courts have been, at a minimum, complicit in this process. But ultimately, it's Congress, right? So Congress hears an outcry over issue ABC. So they pass the ABC Act of 2016 and an administrative law that's called the Organic Statute, and it creates this new agency, the ABC agency. And the problem with these statutes is that they seem to be getting vaguer and vaguer and vaguer. And it's a win-win for Congress because whoever sponsored this bill, if it is a success, can say, hey, this is my bill. And if it's not a success, if there are problems with the agency and the way it's acting, then they say, hey, it's not our fault. We tried to address these issues, and it's the bureaucrats that are out of control. So is it true that Congress is the ultimate source of this problem? And either way, how do we make our congresspeople accountable again and really start to rein in the nature and scope and creep of the administrative state?
I'm glad you asked that. That was actually the point I wanted to make right after Boyden's comment, Linda's comment was, so first, this is probably the only time I'll ever say this, but Bernie Sanders has a point. And the point is there's a lot of money flowing into politics. And the reason why is exactly the dynamic you express. If Congress has passed all this power over to the agencies, and then it's rational for companies, individuals, to give congressmen and congresswomen enormous amounts of money, essentially to save them from the agency they created. Right? So if you read the papers, you'll often see this senator, this congressman attacking an agency that he or she probably voted to fund and create because they made some bad decision for Pennsylvania. Right? They're essentially saying, give me money, vote for me, because I'm going to save you from this behemoth which I actually helped create. And it's this weird dynamic where the Congress is not, we don't hold them responsible for creating the agencies in the first place. We think of them more as rescuing us from the things they created. And so that's why I think one of the reasons you see enormous amounts of money then pouring into the political system is because there's a lot of money at stake as the agencies expand their jurisdiction. They start regulating more things. In the book, you see a laundry list of everything agencies regulate from. I mean, I was struck by it when I read some of the chapters from baby bassinets are regulated by the federal government. The amount of things that are regulated isn't really extraordinary. But if you manufacture baby bassinets and you think a regulation is wrong, what are you going to do? You're going to go to your local congressman or congresswoman, and you're going to give them campaign donations that they're going to listen to. So it creates this very unhealthy dynamic, I think, in our political system with Congress. Also means congressmen and congresswomen can avoid any responsibility, right, for all these decisions. They'll say, that's a terrible decision by the EPA, or that's a terrible decision by the Department of Homeland Security on. I'm going to do everything I can to change it for Pennsylvania. But they're the ones who actually gave the power to the agency in the first place to do it.
So we always get lots of good questions from the audience, and I'm still sifting through them, but this one stood out about the relationship between the federal budget and what goes on within the agencies. So the exact question is, can you talk about how Congress backdoors influence over agencies through the budgetary process?
I would say not enough. I don't consider that a backdoor at all. I mean, if students of the Constitution who walk through these halls know about the Congress's power of the purse. And when it comes to what one thing Congress can do to rein in agencies, it's to exercise the power of the purse and to require agencies to do what they're supposed to do. It's too often the case that agencies start with last year's funding level, and they feel entitled to a little bit more. And I want to connect up some dots that we mentioned before about this sort of vague delegation of power. That goes to these agencies, and you mentioned separation of powers. The CFPB is a pretty egregious example, but many of the agencies we discuss in the book lack a separation of powers within the agencies. And because the statutes they inherit are vague, they get to define the real rules. So they become the lawmakers, in essence. And their staff are the investigators of the regulated community. They go out and they look to see what the regulated community, including people in this audience, have done wrong. And then their staff become the prosecutors and bring actions against the regulated community and the people. And they bring them in front of administrative law judges, which are judges employed by the agency. And this process can take months. It doesn't include the formal rules of evidence that protect people. It doesn't have formal due process that protect people in the regular Article III courts. And it takes months to unfold, tens of thousands, hundreds of thousands of dollars for people to defend themselves. And only after that process do you get to a real court. And by the time you get to a real court, that court, back to the deference question again, is going to start with the presumption that what the agency did in holding against you was correct. So it's a confluence of a lot of things. I think Congress bears a lot of the responsibility, but the courts, I think, can go a long way to solving the problem by not allowing Congress to delegate in the first place, and then really scrutinizing agency action and appreciating that agencies are acting without a separation of powers that really is antithetical to what we think about American due process.
Let me just add, to repeat what I said before, that the CFPB, this agency that was created by Dodd-Frank, it isn't funded by Congress. So Congress has no power of the purse. And that's why the director could say to this congresswoman, why do you care? What's it to you? Why are you asking me? I mean, you haven't had anything to do with this. So the Congress is going to the extent of even, giving its own power away over the purse, which is really, really dangerous. And just tell you one anecdote, when I was in the White House, and this is quite a long time ago, this is back in 1990, 89, we were worrying about trying to figure out ways to reform some of the stuff that was already bubbling up even 20, 25 years ago. And I made the suggestion, which was made in a paper that went around and circulated through the White House staff and Vice President Quayle, that we had rules that any private institution, company, or even individual, usually company or labor union, who sought to influence an agency decision either directly at the agency or at the White House or their little office called at OMB, which oversees and reviews rules, that any individual who went in to lobby had to be publicly logged and disclosed to the public that so-and-so had gone in to try to influence the outcome of this agency process. I thought that it would really clarify things. So to cut off an end run, which was being used by everybody, which is you go to the Congress and get them to lobby the agency, and then you laundered your request and nothing ever gets disclosed. So my proposal was to have Congress efforts to lobby agencies be disclosed to the public. And it took about 30 seconds for Dan Quayle to be in my office and said, Boyden, you keep this up and you're out of here. So it didn't last very long, my suggestion.
Linda.
Well, I was going to say, the root of all evil is money. I mean, let's just put it out there. It's true. And Dean, you're absolutely right. Congress does not exercise the power of the purse strings. Everything continues to grow, and you create a constituency. And I will tell a quick story. In 1983, when I was named the director of the U.S. Commission on Civil Rights, it was a very contentious time. President Reagan had nominated me, a lot of opposition. I came in, and one of the things that I realized is that the agency was a small agency, but that we actually had too much money. And I came in August, and funding ran out on September 30th, and there were a few $100,000 left in the budget that hadn't been spent. And everybody was pounding on my door, well, I need a new couch for my office. Oh, I think the agency needs a new car. We need this, we need that. And I said, you know what? I'm not going to spend the money. What happened? I get a call from OMB at the end of the fiscal year. You didn't spend your money. What is it you expect us to do with this? Well, maybe it could go to help retire a little bit of the national debt. I don't know. The irony was that the Democrats in Congress were so unhappy with the job that I was doing at the Civil Rights Commission that they decided that they were going to cut my budget in half. They also I didn't have a single budget. They separated it into 6 different parts because they wanted me to spend money a certain way. What that allowed me to do was essentially to get rid of half of the staff. And I will say that my most proud achievement in all my years in public life was that the budget of the agency was cut in half, and it has never grown back to the size that it was when I was first took it. But that's the problem. There's a built-in money machine. It's staff, it's people, and those people vote, and they, can cause problems and go lobby their members of Congress. Oh, gee, we don't want to lose these jobs. So it's a money machine that is very, very difficult to stop.
Some of the questions from the audience have addressed the ubiquity of the effects of these programs in all of our lives, right? So most of the people in this room, or certainly their family members, are receiving Social Security benefits or all sorts of things that are administered and delivered by these agencies. And then another question about the size of the federal government and asking, hasn't the federal workforce actually decreased? These both actually relate to books that the Templeton Press has published. I will disclose that. The first, Nick Eberstadt, a few years ago, had a book called A Nation of Takers, and one of the claims there is that essentially we're all on the dole now, right? There's welfare, there's corporate welfare, and there's everything in between. We're all afraid to really be too critical of these programs because it might affect our program. And then more recently, John DiIulio published a book with the provocative title, Bringing Back the Bureaucrats, where he claims the federal workforce over decades has more or less remained consistent, even though its functions and activities have grown, and a lot of that is through outsourcing and other things. Do our panelists want to discuss some of these issues?
Well, I can quickly discuss what I'd call administrative sprawl. Linda Chavez mentioned the length of some statutes, and they do get unwieldy, and they're not read by members of Congress. But it's a fact that there are tons more regulations and pages in the Federal Code of Federal Regulations than there are U.S. statutes, which sort of gives you an indication of who's exercising power in the country. If there are this many laws and this many regulations, that's a pretty good indicator. And there's one government agency called ACUS, the Administrative Conference of the U.S., that sort of superintends some of the other agencies. And they issued a report in 2012 that I think is very interesting because, among other things, it says that they don't really know how many federal agencies there are. That's troubling, to say the least, especially when you think about how much power they exercise. So,
I'd say I don't think it's actually important how many employees the federal government has as it is what the scope of the regulation. So I would say probably when Obamacare was passed, or we call it the Patient Protection Act or whatever you want to call it, it might not have led to a large number of additional employees being hired by Health and Human Services, but it did place about 1/6 of the American economy under much tighter federal regulation. So it's really, the thing to focus on is not, putting it a different way, the government can actually exercise a lot of power that doesn't even show up in the budget by imposing mandates and requirements and standards. Even if we don't pay for it, it puts the cost off on individuals and the private sector, whether you're trying to figure out what kind of insurance policy to buy, or whether you're a company that has to now conform health insurance to the federal requirements. That's not going to show up on the budget, but imposes a very serious cost on the economy. And so I think actually number of employees and the amount of dollars spent by the federal government actually probably wildly understates how much reach and effect the federal government has on all of us.
So the current chairman of ACUS is Paul Verkyle, who was actually my administrative law professor. A previous chairman, I think in the early 80s, was actually now Justice Scalia. And the court actually has at least 4 people very knowledgeable about administrative law, 3 who taught it, Justices Scalia, Breyer, and Kagan, and of course, Justice Thomas's time at the EEOC. Do you think this is affecting the opinions of the court, their own personal experience having worked with agencies, teaching about agencies? Do you think there's any hope of the Supreme Court stepping in and reining in?
I think there is. I mean, I've said so, but I'll repeat. One of the great lines recently that Scalia penned in a case involving EPA again and its claim of unlimited authority to do anything it wants, where they really slammed the door shut on one of EPA's programs. Scalia wrote, "We're not going to sit idly by on the dock and wave goodbye to EPA as it embarks on its voyage of discovery," which I think is a good way of putting what the courts had been doing, but now feel they're no longer going to do.
And I would agree with Boyden that I think your term was Chevron's unraveling, I think, maybe. And I think that's the courts, meaning the courts are going to be getting more involved in this, because I think they're seeing the problem in a new way. The Dodd-Frank bill, I think, required something like 170 individual rulemaking procedures, which is just extraordinary. It's one act, and it requires 176 different rules from various federal government agencies. So I don't think the courts are going to continue on the current path.
And the court is going to be hearing the immigration decision this term. It's been argued, and it will be determined, and I would be astonished if the executive actions that were taken go forward as proposed.
I would think that you see some glimmerings that there are some justices who want to reconsider this whole structure, which is really governed since the 1930s. But I don't know if they'll do it, if they'll really do it in the end, because if you're like Chief Justice Roberts or you're Justice Stephen Breyer, Justice Ginsburg, do you want to spend all your time reviewing regulations about pollution permits and another federal regulation, how are computer keyboards designed? Or do you want to talk about the First Amendment and whether nude dancing is free speech? I think they would much rather do those latter cases, and they don't want to get in the nitty-gritty of running them. I think that's really a lot what's behind Chevron, too, that we talked about earlier, is it freed all the federal judges from having to get in the nitty-gritty of observing agencies and seeing everything they were doing. And that's why I think because if you're a federal judge, you love to talk about, the great amendments to the Constitution, the Bill of Rights, and not so much about pollution permits. So I hope that they're going to renew about this, but the incentive for individual judges is not to do this, I think, unfortunately.
Let's do one more of our audience questions. Someone asked if Congress would have a way of requiring, before it went to the Supreme Court, that a case involving an administrative agency come back to Congress so they could clarify their actual intention regarding the agency and what's going on. Does anyone want to tackle whether that could happen, whether Congress would be interested in actually taking responsibility like that or not?
Well, there is a bill pending called the Reins Act that would be vetoed by our current president, but probably not by a Republican, that would require every agency rule to go to Congress to be enacted before it became effective, and that's not a new idea. This is something Justice Breyer suggested when he was in academia, so it's not a new idea, and it's a very good idea in my view.
There's also the Scrub Act, which is sort of like the BRAC Commission that reviewed military bases. The Scrub Act would require a look back at existing regulations, and a bipartisan commission would just get rid of some of the regulations. So there are various things Congress can do if they're so inclined.
Is there hope? All right, I'd like to thank all of our panelists, Jeff, the NCC. I think it's been a great event. Thank you all.
Thank you.
Thank you.